So welcome everyone. So we were doing Bharatiya Sakshya Adhiniyam. So we were on the first part of that Adhiniyam, which deals with the relevant facts, the facts which we can prove before the court. So actually we are left with only 3 topics of this part, as I have already discussed at the end of the previous lecture, that 3 parts which remain are: first one is the previous judgments, and the second one is the your expert opinion, and the last one is the how character is relevant in civil or criminal trial. So most probably we will be completing these 3 topics in 3 days. So for today we will be taking the bunch of sections of previous judgment, which deals with the sections from section 34 to section 38, and tomorrow we will take on the relevancy of expert opinion, which deals with the sections from section 39 till section 45, and day after tomorrow we will be studying how character is a relevant fact under any civil or criminal trial, and the sections dealing with that are section 46 to section 50. So let's begin our today's session. So what do you mean by previous judgment? Judgment means declaring substantive rights of the parties by civil court. So previous judgment, how it will become relevant under new or subsequent suit. So for example, section 11 of Code of Civil Procedure, which deals with res judicata, which bars the subsequent suit. What does res judicata means? When any matter which is already decided by a competent court, then the same matter cannot be adjudged by the court in subsequent suit. So for example, there is a dispute between A and B regarding the possession of property, and civil court declares A to be in possession of that suit property. So after that, after the decision of that court, so B cannot initiate a new suit on same matter, because it will be barred by res judicata. So here the previous judgment, which is barring the subsequent suit, is becoming relevant, which is helping the court to bar the subsequent suit. So here the previous judgment between A and B, which deals with the matter of dispute of property regarding the possession, which is helping the court to bar the suit. So in this way the previous judgment is becoming relevant. So I will make you more clear by reading the statutory enactment. Section 34. The existence of any judgment, order or decree which by law prevents any court from taking cognizance of a suit or holding a trial is a relevant fact when question is whether such court ought to take cognizance of such suit or to hold such trial. So we have discussed the civil side. So let's take example for a criminal side. So there is a section 337 under Bharatiya Nagrik Suraksha Sanhita. When we will study that subject, we will study in detail, which deals with the double jeopardy, along with the line of Article 20 clause 2 of Indian Constitution. Ki kehta wo? So for example, when accused person is tried before a competent court, whether he is acquitted or whether he is convicted, so for same facts he can't be tried again. So this is the principle of double jeopardy. In same sense, so section 34, which allows the court to to make its decision whether it has to bar the subsequent suit, whether it has to take cognizance or not on the basis of previous judgment. ठीक है जी, चाहे सिविल साइड हो चाहे क्रिमिनल साइड हो, विच अलाउज द कोर्ट टू टेक डिसीजन भी उन्हें ट्रायल ਨੂੰ ਕਮੈਂਸ ਕਰਨਾ ਜਾਂ ਨਹੀਂ ਕਰਨਾ in case of criminal side and in case of civil side, whether it has to try the matter or not, then that previous judgment will become relevant under section 34. ठीक है जी. So this is section 34. Now let's begin with section 35, which deals with the conclusive proof of legal character of a person. So for example, in any civil suit which deals with your probate, matrimonial disputes, admiralty or insolvency proceedings, जे मैटर ए चार situation cha, that is probate, matrimonial, admiralty or insolvency, and the court has provided some legal character to a person, or court has snatched away any legal character from a person, that fact will be a relevant fact in a subsequent suit, and that will be of a conclusive nature. ठीक है जी. So under section 35, what is becoming relevant? The legal character of a person in relation to matrimonial disputes. So for example, if there is a matrimonial dispute, a civil court has granted a divorce to a person, so that is a legal character of a person, that the person is a divorcee. So that fact is of conclusive nature and will be relevant under subsequent suits. ठीक है जी. So section 35 that deals with the conclusive nature of legal character, that will become relevant fact in subsequent suit if it deals with 4 types of conditions that we have already discussed. And make this thing in your mind that the legal character provided by a court will be of a conclusive nature. What does that mean? The opposite party will not be allowed to present evidences to rebut that conclusive nature of that legal character. The court will assume it, and the other party will not be allowed to give evidences to rebut that. So that's it. So let's move to section 36, which states that judgments, orders or decrees other than those mentioned in section 35 are relevant if they relate to matter of public nature, relevant to inquiry, but those orders or decrees or judgments are not of conclusive nature. So this is the residuary section, section 36, which states that any matters which are not covered under section 35, what are those matters other than probate, matrimonial, admiralty and insolvency proceedings? So all matters other than those proceedings, if it in them any public right is declared, any right of public nature is declared by court in form of decision, then that decision of the court will be of relevant fact. But keep this thing in your mind, that will be not of conclusive nature. So this is the difference between section 35 and 36. Under section 35, the legal character provided by the court will be of conclusive nature. What does that mean? The other party will not be allowed to give evidences. But under section 36, that decision relating to public right will be relevant fact, but it will not be of conclusive nature, and other party, the opposite party, will be allowed to give evidences to rebut that assumption by the court. So let's take an example under section 36. Suppose there are two persons, person 1 Michmash, person 2 Martin Guptill. So both persons are having dispute regarding the possession of some house. So there is a dispute of possession between Michmash and Martin Guptill. So for example, they went to court and the court gave decision that Mitch Marsh is entitled for possession of that property. So here Martin Guptill is not entitled to the possession of property. So this right is of public nature. Suppose now Mitch Marsh is in possession of that property. Now there is a dispute between Mitch Marsh and Glenn Maxwell. Now Glenn Maxwell is third person who was not party to the suit in the previous proceeding, so matter will not be hit by res judicata because the parties are not same. So here the judgment between Mitch Marsh and Martin Guptill will be of a relevant nature because public right is declared in that, but that will not be of conclusive nature. So here the dispute, the suit between Mitch Marsh and Glenn Maxwell, here Glenn Maxwell can present evidences to prove that he is entitled to possession because the right declared by the court in previous suit is not of conclusive nature. That is only a relevant fact. So this is the difference that I tried to convey you between section 35 and section 36. So this is the major difference, that is of conclusive nature of the decision. So in this way we have covered section 36. If you feel any doubt or any query, you can just message me or you can call me or you can comment below so that I can address your doubts appropriately. So we are left with the two sections of this bunch, that is section 37 and section 38. Section 37 is the residuary section again. It states that any judgment or decree or order that is not mentioned under section 34, 35 or 36, which is not mentioned, so it is a residuary clause jo kehda wa if the any judgment that is in matter that is in issue or it is a relevant fact, then that judgment can be proved. ठीक है जी. So let's take an example for section 37. Section 37 की कहता हुआ if any case, any previous judgment that is in issue means directly involved आ थोड़े suit च, then or it is a relevant fact other than section 34, 35 or 36, then it can be proved. So let's take an example. A prosecutes B for stealing a cow from him. So this is illustration B of your section 37 from your Bear Act. So A prosecutes B for stealing a cow from B. A prosecutes B for stealing a cow from him, and B is convicted. So B is convicted for theft of cow of A. Now afterwards, after the conviction of B, A sues C for the cow which B had sold to him before his conviction. So B ਨੂੰ ਸਜ਼ਾ ਹੋਗੀ for the theft of cow ਜੋ ਕਿ ਉਹਨੇ ਚੋਰੀ ਕਰਨ ਤੋਂ ਬਾਅਦ C ਨੂੰ ਵੇਚਤੀ ਸੀ. Now A sues C for cow that B has sold him. So as between A and C, the judgment against B is irrelevant. ठीक है जी. So ਇੱਥੇ the matter is different. The matter is not an issue, ना ही relevant है. Even though B is convicted, the question before the court is that whether in a suit between A and C for recovery of price of cow, whether the judgment of B's conviction will be a relevant fact or not. The answer is no, it is not relevant because it is not an issue and not a relevant fact and not even declared any legal character or not declared any right of public nature. So it is not relevant under section 34, not under 35 and not under 36. You got my point? So now let's take another example. So A is charged with theft and with having been previously convicted of theft. So A te charge hoya theft da, te before that charge he was also previously convicted of theft. ਉਹ ਚਾਰਜ ਦੇ ਸੂਟ ਤੋਂ ਪਹਿਲਾਂ ਉਸ ਤੇ ਪਹਿਲਾਂ ਵੀ ਪ੍ਰੀਵੀਅਸ ਕਨਵਿਕਸ਼ਨ ਸੀ. ਹੁਣ ਇਹ ਜਿਹੜਾ ਨੈਕਸਟ ਸਬਸੀਕੁਐਂਟ ਟਰਾਇਲ ਆ ਇਹਦੇ ਵਿੱਚ ਉਹਦਾ ਜਿਹੜਾ ਪ੍ਰੀਵੀਅਸ conviction of a theft will be a relevant fact. under section 37 from which the court can draw inference. You got my point? If so, section 37 ਕੀ ਹੈ? Residuary clause ਆ, ਜਿੱਥੇ 34 ਵੀ ਨਾ ਕੰਮ ਆਵੇ, 35 ਵੀ ਨਾ ਕੰਮ ਆਵੇ, 36 ਵੀ ਨਾ ਕੰਮ ਆਵੇ, then 37 ਕੰਮ ਆਉਂਦਾ ਵਾ। ਠੀਕ ਹੈ ਜੀ। So let's